handling any of yours. Apparently he's keeping
So let it.
Good morning. Need
Hey, Mr. Representative, if that's what you want to do.
All right.
Okay, good morning. We're here on our miscellaneous criminal docket. And do you have Washington here? Because that's scheduled for 11. Okay, but it's number one on your thing. I just wanted to make sure. I agree. Okay, so we'll begin with David Cornell. Oh, Ms. Dudley said she was going to be running a little bit late, so we'll pass over Cornell. Actually, we'll pass over all of the next three. They're Miss Dudley's, just, she can let us know when she's, are you here for her?
Yes, on the Williams case, Your Honor.
Okay. I just had her down, and they said she was running a little late.
Yeah,
So
go to the puny act this month.
sure, that's all right. Jasmine Williams, with the state, we can announce.
Your Honor, Jasmine Williams, 20 CF 1075.
And Your Honor, I'm here for Ms. Sandler this morning.
Okay.
And Miss Williams is in lockup.
They're bringing her up.
Got a new card. And I switched banks yesterday and got a new card. So I gotta do it on transfer.
You send it again later.
If it please the court, Your Honor, Don Durrell for Miss Jasmine Williams in case number 20 CF 1075. We're before the court today, Your Honor, for sentencing. The plea has previously been entered, I think, on March the 29th of 2022, and the plea was accepted. Sentencing was set off to accommodate the provisions in the plea agreement that required her to testify against a co-defendant who has now entered a plea and been sentenced.
So that requirement has been met?
Yes, Your Honor.
Okay. And the only question I have is, has the restitution been determined? Because on the plea agreement, it said restitution if applicable. Just, I don't know if we're...
None has ever been determined, Judge.
Okay.
And-
So
and, Your Honor, if we could just reserve on that, I didn't, I
Well-
didn't see in the file that,
Judge,
This is March
We've been reserving
29th of
6 months.
2022. This was filed, the sentence agreement. So, I mean, I don't know exactly when we entered the plea agreement. Did we not, normally we give a certain amount of time. Did we not do that on this case?
Your Honor, on the plain sentencing agreement, I do not see a determinate amount of time.
No, I understand that, but you didn't address that?
No, Your Honor, it does not look like it was addressed.
Judge, it would be our position that any restitution amount should have been determined by now. The plea's been entered for over approximately 6 months. But if the court wants to give the state an additional time, we would ask that it be limited to a very specific time of like 2 weeks.
Do you have any information? I mean, I know you're filling in for somebody.
No, Your Honor, if I would just add, if we could do 30 days, that's even less than the normal time we asked to reserve.
Well,
I think.
normal, but the normal time is not 6 months. So you've already had 6 months. So I'll agree. You can do it in 2 weeks. The only reason I'm doing it is because I just don't have any information because the state's not here. And it's not your fault. I'm not blaming her, but there. So I'll give you 2 weeks to determine, and we'll reserve for 2 weeks. If it's not, it'll be kind of waived by the state. And Ms. Williams, if they do file something, you still will have a right to contest any restitution. So based upon the plea agreement, the court, there is an adjudication of guilt on all 3 charges?
Your Honor, I think
Yes.
count 2 is dismissed. So count 1 and count 3. there would be-
There's only 2 counts that plea was entered into, Judge. Count 1 and count 3.
Very good. And so the court will sentence to 6 years, Department of Corrections. Of course, you will get credit for all time served, followed by 9 years of probation with standard court costs. Can we go ahead and identify those court costs so we can?
15th.
The clerk help out with that.
He'll be fine.
515 in court costs?
Yes, Your Honor.
Very good. And of course, the reserve on restitution for 14 days. If it's not filed, it'll be waived. And the testimony that's contained in the plea and sentencing agreement by, not stipulation, by agreement with the state that requirement has been met. Anything else that we need to do here today, Mr. Durrell?
Nothing, Your Honor.
Okay. Thank you very much.
Thank you, Your Honor.
Your Honor, we'll request the supervision fees be waived.
Yes.
Yeah.
Yes.
Thank you.
Thank you. Is that your only case?
That's my only case.
Okay.
Judge.
Thank you. You have a
And
nice
my
day.
last case, Judge.
And Your Honor, the score sheet has already been filed for the court, and
Right.
the court signed it.
All right. Thank you, Mr. Durrell.
Excuse, Your Honor.
Thank you. You may.
Yeah, good point.
Mr. Keach here.
No, Your Honor, not yet.
Mr. Powell. John Davis. Good morning, sir.
I don't think Mr. Davis is present. We've got a motion to withdraw, Judge. I cannot continue to represent this defendant. He's failed to comply with our contractual agreement. He's been all uncooperative, and he sent me a text that he didn't want me as his attorney.
Was he noticed of this hearing?
He's not here, but he's had notice of the hearing, and I've talked to him all last night.
Very good.
The state has no objection to Mr. Powell getting off the case, and the state would ask for a capias for his failure to appear.
But it's on a motion to withdraw. I wouldn't ask for a
I'm not
capias on that.
going to do a capias, but I'm not going to appoint him an attorney. He's going to go without an attorney on the next case. What is the next?
1024 and 1026.
And that was he was previously ordered on 1024. So we'll deal with that at his next court hearing. But I'll grant yours if you'll
Thank you,
get us
Judge.
an order, Mr. Powell.
I got an order here too, Judge.
I think you got to file it through the,
Want me to file it through the portal?
yes, I think that's what they're asking. Okay.
Thank you, Judge. Good
Thank
to
you,
see
Mr. Powell.
okay?
Michael Blasberg. Mr. Stewart.
Good morning, Your Honor.
Good morning, Mr. Stewart.
May it please the Court, Your Honor, Brad Stewart, on behalf of Mr. Blasberg. Judge, this is in 20 CF 707. It's violation of probation. We've previously entered a written denial on the matter. I'm going to request that this VOP case track along with his new law violation. And for the record, that case number is 22 CF 2239.
And when is that hearing scheduled for?
If we can,
Did
Judge.
you say you've already entered a denial in this case?
Yes, Your Honor, we have.
Okay.
If we can, Judge, if we could put it on the October cycle, if it's pleasing to the Court.
Is it 1026 for in custody?
It is.
1026.
We could put both cases, Madam Clerk.
Very good. And that'll be at 9 o'clock, standard start time. Okay. Anything else on this case?
No, Your Honor.
Thank you very much. Mike, is that your only case?
Judge, that's all I have on today's docket. May I be excused?
I think.
Thank you, Your Honor.
Okay. Is Mr. Whitmire here?
He is.
DeAndre?
Yes, sir. It's case 20 CF 1077.
Good morning.
That's 515.
Your Honor, Ms. DeAndre is a co-defendant of Ms. Williams, whose case you just heard. We entered the plea back in April of this year. Same circumstances. The score sheet's already been reviewed and filed, so we're here for you to impose sentence. The same restitution issue would be at hand. We'd ask for the same 14 days for the state to comply with any restitution requirement.
And the state is in agreement that the testimony requirement of the plea agreement has been met?
Yes, Your Honor, it has been met.
So based upon that, this is just sentencing from that previously entered plea agreement?
Yes, Your Honor.
And based upon that, the court will sentence the defendant to 6 years in the Department of Correction. You will get credit for all time served. That will be followed by 9 years of probation. The court will waive supervision costs for the probation, standard court cost, which I think is $515 in court costs, and the testimony has been, that requirement has been met, and the court will reserve on restitution for 14 days, giving the state the opportunity to file within that time period. If not, it'll be waived. If it is filed, you all can figure out whether you're agreed. If not, we'll deal with it.
Yes, sir. Thank you, Your Honor.
Very good. Anything else we need to do here today?
No, Your Honor, the guidelines sentencing has already been filed.
And I just want to explain the restitution to my client. Thank you, Your Honor. That's all I have. May I be excused?
Thank you. Have a nice day. Okay, Noel Bryant. Hold on just a second. Let everybody get out so that I'm going to make a general statement here. So we've got the next 1, 2, 3, 4, 5, 6 cases do not have attorneys. So I want to speak to those defendants who are here, starting with Ms. Bryant. The purpose of today's hearing is almost like a plea. It's on a miscellaneous, but it's a violation of probation. So the purpose of today's hearing will be to determine whether or not you deny or admit the allegations in the violation of probation. There may be some discussions. If you have had some discussions, we can deal with it. But you, at this point, have not had an attorney. You do have a right to an attorney, okay? So the first thing I'm going to do when everybody comes up, I'm going to ask you if you want an attorney. And if you're not hiring your own attorney, unless, you know, it's kind of just a technical and it's not a major change, if there's anything at issue, you need to accept the attorney or hire one. At that point, I'll enter a denial. We'll come back so you have a chance to meet with your attorney. Okay, so do you understand what I'm saying? Okay. So on this case, this is case number 2020 CF 2416. It is a violation of probation. Do you wish to have an attorney appointed? Okay. Court will appoint the public defender. Court's going to issue a denial, and we'll come back. When do we want to come back? Without subpoenas on October 19th.
That's
that too tight?
Yeah, could we do
May I
1027?
have a moment, Your Honor? Because I think this was,
Might be able to be resolved.
there was a case last.
I was here last week, yes,
She was here last week.
last Thursday.
She paid it.
She just has to give it to probation, and probation acknowledge it. Yeah, this one was the one that we continued, and if she made full payment, then we wouldn't go forward.
Right. That's why I was like, hold on, wait, I'm looking.
Same day.
Your Honor, yeah, she went down there, I believe that day, and paid that outstanding court cost.
Okay.
And we have record of it.
So does that resolve this VOP?
It does, Your Honor.
Okay.
The state would ask that you dismiss the VOP.
VOP will be dismissed. You do not have to come back. You don't have to have an attorney or anything.
Yes, sir,
Okay?
thank you.
Okay. Isabella Delaquila, if I pronounce that correctly.
Yes, Your Honor.
She apparently had another case.
Yeah, they didn't bring them in together for some reason. We do a concurrent.
Would the state announce?
Your Honor, this is 20 CF 193. This is a violation of probation.
And Your Honor, technically, we are not appointed right now. However, I guess we should have been because she had 2 VOPs. We already resolved one last time, not knowing there was a second one.
Okay.
So,
VOP was a ticket that was dropped in Seminole County. It was only one VOP.
it's just
Oh.
2 cases. 2 cases is what we're saying. We're not saying 2 VOPs.
So
We're saying 2
let's,
cases.
let's take one thing at a time. You do want to have an attorney appointed on this case because you don't have one. Okay, so I'm going to appoint the public defender. Do we just need to enter a denial here today and try and resolve, or is there something that can be resolved today?
I think we can resolve it, Your Honor. I can just write it up and then we're ready to resolve.
Okay, so you want to come back on this, hold it?
That's fine. If you, yeah,
Okay.
just hold her from, yes.
So it looks like we'll be able to resolve this. Okay. Elizabeth Graham.
Your Honor, Ms. Graham's before the court on 20 CF 2264 and also 22 CF 570.
Okay. So, Ms. Graham, as I said, you do have right to an attorney. You wish to have an attorney appointed. The court will appoint the public defender in both cases, and the court's going to issue a denial, just so you can preserve your legal rights, and we'll come back.
We asked for 1027, Judge? Okay, November 2nd then.
Okay, November 2nd.
Thank you, Judge.
Clifford Gray.
Your Honor, Mr. Gray's case, I spoke to the attorney on Mr. Gray's case yesterday. In this particular case, he entered a plea on September 28th, 2021 to 5 years DOC. The DOC was to run retroactive to a 2017 date. He has completed all his time. This is not a violation of conditional release. This is not a violation of probation. This is nothing. There is nothing. His case is closed.
So has there been a VOP filed?
No, Your Honor. The one that is before the court is the one that was pled to back on September 28th, 2021.
So this should not have been brought before the court?
Correct, Your Honor. This case, the VOP that...
Nothing needs to be done on it because it's already been...
Dismissed, yes.
Okay.
This new one has to be
Okay,
dismissed.
so I'm just going to put an X by this that
Closed.
should not have been,
That's correct, Your Honor.
oh, and he's not an inmate, so, okay.
That should have gone to the parole commission or the offender review program and not to Mr.
Okay. Anything else we need to do on this case?
No, Your Honor, just
Okay.
that if, he posted a bond, which I think they just released him because they noticed the issue, just to give it back to him.
We'll take care of that, Judge.
Okay, thank you. Mariah Jernigan. The state announce, please.
Yes, Your Honor. Ms. Jernigan is before the court on 19 CF 367.
And Ms. Jernigan, as I mentioned, you do have a right to an attorney. You wish to have an attorney appointed?
I already have a lawyer, Mr. Nopes.
And Mr. Nobes is in front of Judge Selector right now, and
Is he attorney of record?
Not according to this.
Okay. So we'll do this. I'm assuming you need to tell him that he needs to make an appearance. You need to tell him that. Okay, he's not technically made an appearance in this case yet, but I'm going to assume that we'll put it off so that we'll go ahead and enter a denial on your behalf, and then we'll come back on, let's try and do it, we'll do it on October 19th at 9 a.m. But make sure that tell him he needs to file something, tell him the court said you haven't made an appearance. That's just, no, he hadn't filed and said, I'm the attorney.
Okay.
Okay.
I'll have her with the judge. I mean, he actually showed up last time
Yes.
representing her, but he obviously hasn't filed the proper paperwork.
Ah, okay.
Yes, Your Honor. And like I said, he did give notice that he's in front of Judge Selector.
That's fine. But we'll enter a denial. It's not, you're not giving up any of your rights. You can meet with him. We'll come back on 10/19, and you can meet with him before then, and they can have whatever discussion with the state.
Okay.
Question?
No, sir.
Okay, thank you.
Your Honor, I can represent to the court that since she was released on bond, that she has been complying with the terms and conditions. However, it's over in Santa Rosa County that she's being supervised out of, and they have indicated no problems with her since she was released on bond.
Okay, very good. Thank you. Ethel Morgan.
Your Honor, Ms. Morgan is before the court on 19 CF 1093.
Ms. Morgan, you do have a right to an attorney. You wish to have an attorney appointed?
No, sir.
No? Okay. Do you want to enter a denial or an admission? What? Do you hear my little speech? We're here basically on a plea.
Right.
Okay. Where are we at? The state, help me out. Have there been some discussions?
There has. May I help for just 1 second?
Sure.
She's done everything. She's in Bridgeway right now. She just has a few classes left. What we discussed was, I didn't give her any legal advice, but if she gets a public defender, it's going to cost her more money. She has proof that she's in classes. If there's a way we can enter a denial and continue it, I know I can't legally say that.
And that's fine, Your Honor. Ms. Glisson's offer was to extend it for 6 months, to give her the opportunity to finish. But if we want to continue it, that's fine as well.
Is she aware of that offer?
I have no idea, Your Honor. It's Ms.
Have you
Glisson's
had a
case.
discussion with Ms. Glisson anybody make an offer to you about this violation of probation?
I've only talked to my probation officer.
Okay, so why don't we do this? I'm not going to appoint. I'm going to enter a denial, which will preserve your rights. You just say, I didn't, and we're going to come back on 10/19 at 9 a.m. And in the meantime, if you'll ask Ms. Glisson to try.
She will not be here she will not be back by 10/19, Your Honor. And if she's trying to complete something, if we could give her till 11/2.
Okay, so we'll come back on, I'm going to change that, November 2nd. Okay, we'll come back, and hopefully by that time you can communicate with the state, and there'll be some resolution, you'll be further along with what you're doing. The main thing is, we want you to be successful and to do these things, and it looks like you're making a good faith effort to do that, so keep doing it. Okay? Okay. So we'll come back November 2nd, 9 a.m. Okay? Thank you. Roydell Murray. Did the state announce this is a little bit of an unusual
Yes, Your Honor,
case?
this is 19 CF 708.
So the court received this pro se motion to modify probation, and so I basically just set it for a hearing, just to
Yes,
kind
yes, Your
of
Honor.
figure out what's going on with it.
My understanding is that he's requesting a modification to travel out of state for work purposes. The state has no objection as long as state probation is okay with it.
Your Honor, we can give him permission to travel out of state. The travel permit is only good for 30 days, meaning he would have to return every 30 days. Was something different than that?
I actually transport cars, so I'm gonna be back before that. But I'm sorry. I do transport cars, Your Honor, and within the states, the loads are very limited. So I go out and come back. I just want to do the southeastern states.
Okay.
As long as he returns back to the state of Florida, the travel permit is going to be good for 30 days. We're going to tell him when he can leave and when he can come back. And if he has to go 2 or 3 times during that period, that's fine. But you have to come back every 30 days and see your probation officer in the probation office.
Yes, Your
Can you
Honor.
do that?
Yes, I do. I come back every week.
Okay.
So it's just, but it's the permanent job. So I don't know if it's just for 30 days or if it will be.
Well, it'll be 30 days, but then they'll do it for another 30. You know, you got to check in every 30 days.
Okay, yes, sir.
Just follow their direction. As long as you're coming back every 30 days, inside, before 30 days.
Yes.
You know, maybe you make 2 trips in that 30-day period. That's fine. You can go in, you go out, but you got to check in every 30. You just got to follow their directions.
Okay.
That's the main thing. Stay in good contact. Make sure you understand what the check-in requirements are, and that can be done. Do we need to take any action on this
No, Your Honor.
based upon that?
No, Your Honor.
Okay, so there is a motion to modify. Is there an order or something that needs to be, or is that just something that will be dealt with through probation administratively and no action necessary by the court?
If the court gives me permission, I'll relay that information to the probation officer.
Court will grant the opportunity to travel within the restrictions, the requirements to check in as just explained by the probation officer, okay?
Thank you, Your Honor.
Okay, very good. Thank you very much. Okay. Ms. Flowers, you want to try and run some of you, or you're doing some other ones? We can skip over them? You want to? Sure. Okay, I've got Jeffrey Miller. Okay.
Your Honor, this is Jeffrey Miller, Jennifer Flowers on his behalf. Case number 21CF1120. We're asking for a continuance today. We had worked out an agreement with the state for admission on the VOP, but then we became aware of possibly another pending VOP. So we're just going to
resolve all of them. Okay.
Yes.
Can we come back on October 19th? Is that?
We can try. My only, I'm not sure when Ms. Glisson gets back.
She won't be back.
So I
Are you negotiating with Glisson?
Yes.
Okay, so
like-
we'll come back on 11/2,
Okay.
November 2nd at 9 a.m.
Thank you.
You want to do the 3 inmates?
Sure.
Okay, let's start with Alexis Baggett.
And good morning, Your Honor. This is Alexis Josephine Baggett in case number 21CF868, Jennifer Flowers on her behalf for the record. We're going to ask for a continuance today to get an offer and discovery from the state. Could I have a moment just to speak with her?
She won't get into any of them.
Okay, well then, yeah, we'll just be asking for a continuance.
Okay. Who are we negotiating? It's the same question as Ms. Glisson.
It'll
Is
still
it
be Ms.
Glisson?
Yes.
Okay, so we'll come back 11/2 at 9 o'clock. November 2nd, okay? Lena Creech.
Your Honor, Jennifer Flowers on behalf of Lana Creech, 21 CF 2735. We had addressed, we got some things figured out on Ms. Creech's case last time when Judge Gontarek was here. We basically fixed the case where she is 100% on the waiting list now. We still don't have an estimated date of transfer to Florida State Hospital, but she is completely confirmed that she's on the list and awaiting transport.
What, should we just, how long, I think we just need to keep checking to make sure that, you want to maybe, how far out?
I would say a month out.
11/2.
11/2.
Okay. 11/2. For a status conference at 11/2. Okay. Okay, thank you. Abe Hicks.
Your Honor, I'm covering for Ms. Bergman this morning. This case.
Yes, Your Honor, this is Mr. Abe Justin Hicks on 2019 CF 96. Jennifer Flowers on his behalf. He is prepared to enter into a plea of no contest for the agreed sentence with the state. He's charged with one count of lewd and lascivious molestation, which is at this time, a life felony.
Do you have a copy of the plea and sentencing agreement, a separate one that I can kind of be following with? If you don't, that's fine.
Can he borrow yours?
Yeah.
Okay, that's all right. Thank you.
And as I stated, Mr. Hicks is going to plead no contest to the lesser included charge of attempted lewd and lascivious molestation, which is a first-degree felony with no minimum mandatory sentence. The terms of the plea will be as follows. He will be adjudicated guilty of the lesser included attempted lewd and lascivious molestation. He'll serve 10 years in the Department of Corrections with credit for all time served, concurrent with the sentence in Santa Rosa County, case number 18 CF 240. Defendant is adjudicated a sexual predator as set forth in section 775.21 Florida statutes. He'll have no contact with the victim. $667 in court costs, $100 cost of prosecution, $150 cost of defense, and we're asking that all money be sent to collections after 180 days from the date of this agreement. He wants his mom to pay those court costs.
Is the state in agreement?
Yes, Your Honor, that's the state's agreement. And I have the score sheet for the court if you want me to approach or if you want me to hand it.
And I have the plea, Your Honor. Sorry.
Okay, thank you. You need that, or is
I'll
that?
just give you this complete plea.
Okay, thank you. Okay, Mr. Hicks, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
You, and is the defense in agreement with regards to the score sheet?
Yes, Your Honor.
Okay. Mr. Hicks, you heard your attorney state the terms of the plea agreement. Is that your understanding of the plea agreement?
Yes.
And are you in agreement?
Yes.
Okay. And what I need to do is just to make sure that you understand the full terms. This is You know, there's a lot of components to this plea agreement. I want to make sure that you understand it and that you're entering into it freely and voluntarily, okay? So you understand that obviously the key component is the 10 years Department of Corrections. You'll get credit for all time served. It'll be concurrent with the Santa Rosa case, 18 CF 240. So they'll run together and won't stack on top of each other. Is that what's your understanding? Yes. Okay. And that's obviously a benefit to you, so you're not getting hit with two at the same time. Importantly, there will be an adjudication as a sexual predator. That carries with it a lot of requirements when you get out. Have those been explained to you? Do you understand the checking in, not being around certain individuals, you know? You understand all that? And of course, specifically, you can have no contact with the victim. And you understand?
Yes.
The state takes these no contacts and these requirements real serious. I just want to say that to you. I want to make sure you understand that. This is not a maybe. These are requirements, and they're onerous. They take a lot of effort to maintain those, but you're willing to do that when you get out? You understand that?
Yes.
Okay. The cost, the collections for all the cost and fees after 180 days. And you understand that by entering into this plea agreement, this is the final resolution of your case?
Yes.
Okay? So you're waiving the right, you're waiving several valuable rights. The right to go to a trial, the right to contest it. It limits your right to appeal,
yes,
importantly. Okay? You understand all that? So you're
yes,
limiting your rights by entering in it. Why are you entering? You believe it's in your best interest?
Yes.
And I assume there is a factual basis for this plea agreement?
Yes, Your Honor.
And it's within the score sheet, so it's not a downward departure. So, again, you're entering into this freely and voluntarily. You've had a chance to talk with your attorney in depth about this.
Yes.
You had all your legal questions answered by your attorney?
Yes.
You feel like you've gotten good legal representation?
Yes.
Okay. Any questions here today? No. Very good. Based upon that, the court will. And I do see you've signed the plea and sentencing agreement that I assume you've gone over with your attorney as well.
Yes.
Okay. Based upon that, the court will accept the plea and sentencing agreement and will adjudicate the defendant guilty of the lesser included charge of attempted lewd and lascivious molestation under 12, 10 years of Department of Correction with credit for time served concurrent with the sentence in Santa Rosa case number 18 CF 240, and as well as the other requirements that are contained in the plea agreement. Okay, any questions? Okay, thank you very much.
And Your Honor, that concludes
Yes.
my business in the court this morning. Can I be excused?
You may.
Thank you.
And
I think that's your last case. Do you have
there's
another one?
one on the docket that I was recently appointed to. I think, is Kieran Williams here?
I believe he's an inmate.
Yeah, was he transported?
Wait, what number is that? Do you know what number on our?
I have number 33 on the
You
transport
guys
list.
withdrew from that, right?
Page 17 of the docket, Judge, number 4.
Gotcha. So that's the,
Yeah, here it is right here.
he's here? Okay,
I have a plea.
okay, good. What's the name again on this?
Williams is the last name. First name is
It's Karen Williams, Your Honor. The case number I have is 20 CF 2252.
I don't have that on my, what docket, what number? What number did you say, Marty?
On the docket, I shown it on the last page, number 46.
Okay, I don't have a 46. My docket got it printed out. It's the 130 docket? Oh, okay. That's the, So this is not on today, this morning's docket? What number?
I didn't print a docket, I just knew he was.
All I've got is 13 pages of the docket. Can you print me off everything, page 14 and beyond on the docket? Madam Clerk?
You'll get credit for all that. You'll get credit for all the time. Name on the docket right now, that's what's taking so long.
Pardon? Yeah, I don't. Okay.
I have a plea agreement.
Thank you.
Nope. Good attitude.
You can give that to Martin if you'll.
And Your Honor, for the record, this is Kieran Williams, case number 2020 CF2252. He is going to withdraw his previously entered plea of not guilty and enter a plea of no contest as charged to one count of possession of controlled substance and one count of possession of paraphernalia. To the sentence agreed upon with the state being a withhold of adjudication, 4 months Okaloosa County Jail with credit for all time served. There's a $134.90 cost of transportation to OCSO. There's $515 in court costs, a $100 cost of prosecution, and a $150 cost of defense. And those would be sent to collections after 180 days. I'm not sure if I wrote that on there.
Yes.
I did? Okay.
It does say that. Very good. So it's stated in agreement.
Yes, Your Honor, that's the
Okay.
state's agreement.
Mr. Williams, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
And Ms. Flowers, you're in agreement regarding the score sheet?
Yes, Your Honor.
Okay. You heard your attorney state the terms of the plea agreement, the core of which is the 4 months Okaloosa County Jail with credit for all time served. Is that your understanding of what the plea agreement is? And you understand that by entering into this plea agreement, of course, there's all the costs, et cetera, that are contained in here. That you waive the right to a trial, is a final adjudication. Give up some rights by entering this plea agreement, not the least of which is the right to go to trial, the right to contest the charges, et cetera. Do you understand all that? You've had your legal questions answered?
Sir.
Okay. And you're entering into this freely and voluntarily. I see you've signed the plea and sentencing agreement. Did you go over it with your attorney?
Sir.
Okay. Do you have any questions here today?
I'm there, got.
That I don't have an answer.
The jail connect,
Your Honor, I think it should be noted that the state's not going to take any action on any failures to appear which are associated with this case.
Okay. Can you write that on the plea agreement? Okay. Based upon your testimony. Oh, good. Very good. Thank you. Okay. Okay, based upon that, the court will accept your plea agreement, and the court will withhold adjudication, sentence you to 4 months in the Okaloosa County Jail. You get credit for all time served, along with the court costs and fees that were stipulated to 180 days payable, and then it'll go to collections. The state will not pursue any failures to appear that are currently on the record. Okay? Okay. Thank you very much. Thank you very much.
Judge, I do think that's the last. Ms. Rivers has it.
What's that?
Go ahead.
You need to stay here for Angela Taylor if it's stipulated to. Your Honor, I've got one more on the docket. She's on for a bond hearing.
Okay, what number? What? Oh, it's the add-on? Okay. Okay, go ahead.
It's just a, I was just going to announce that it was stipulated to.
Is this Angela Taylor?
This is Angela Taylor.
Okay, go ahead.
Your Honor, we're here on a bond, motion for bond.
I'm sorry.
Okay.
I forgot, I didn't realize she was here.
And yes, Your Honor, this is Angela Renee Taylor approaching the case number. Case number 22CF1564. We're here on I filed for a motion for bond. However, I believe the state is in agreement to stipulate to reinstate her bond in this case. Bond was previously revoked for a new law charge that has since been dismissed. In addition, the alleged victim in this case was served and did not show for a deposition. The state's not ready to dispose of the case yet, but is stipulating to reinstate the bond.
What is the terms of the reinstatement of the bond? Do we need to put that on the record? Whatever the terms are, but it'd be better.
I believe it would be, the monetary amount I know is $5,000 cash or professional. I believe no contact with the victim, who's Nicole Gray. And were you on pretrial?
Any of the conditions on the original, so we're reinstating the bond with the conditions that are contained in it. And it'll be the same $5,000 cash or professional with the other condition, which are very important to follow through with, because if not, the requirements of the bond are not met, they'll revoke it. Do you have any questions?
Repay the 500?
It'll just be reinstated. You won't have to repay it again.
Okay, so I'll just.
I'm not sure exactly. You're asking kind of a technical.
Yeah, I'll tell you. You won't need it.
Okay.
I have prepared an order. It doesn't, if you want me to approach, if there's anything you want to add to it.
The state. Okay.
If that makes it easier for you.
Okay. Thank you very much.
All right, thank you, Your Honor.
Anything else, Ms. Flowers?
That's all I have today, Your Honor.
Okay. Very good.
I do have one on the afternoon docket for plea day, Amber Lunn, who we have filed a written plea of not guilty this morning. Will that suffice? I don't think the state has an offer.
If there's a written plea, then yeah.
Okay. It was just filed this morning, so I didn't want to.
That's all right. What is it? What's the number? What's the case? What?
It's, the last name is Lunn, Lunn.
Okay. We'll just make a note that there's been a written not guilty plea entered. And you
Okay.
do not have to come back, and we don't
Is it
have
in
to
my
have
case number?
transported.
Oh, okay, I'll just go talk to him. Yep, I believe that's all I have, Your Honor. Thank
Okay.
you for.
Very good.
Pretrial 1024.
So I see Mr. Creech. Where did he go, Jeremy? Are you ready to go, Jeremy?
Yes, sir.
Okay. With this,
Just the state of Florida versus Dakota Jones.
22 CF 211.
Correct, and it appears that we were appointed after Mr. Jones had requested to withdraw a plea that he entered while incarcerated. And I've advised Mr. Jones this morning that I'm not prepared to go forward on the motion to withdraw since I just met him. So I'd ask for a continuance on that. But what I want to clarify is that, and I advised him of this, so I just want to put this on the record, that at the time that he entered his plea, he was incarcerated due to a bond being revoked based on a new law violation that is still pending. So it'd be my understanding, based on the law, that if his plea is withdrawn, that he would have to be remanded into custody.
That's correct, Your Honor.
So do you understand that?
And the state will be seeking that as well.
I just want to make, I don't know if he knew that, so I just want to put that on record. Do you understand that? Okay, all right.
So we'll continue this, the motion to withdraw on the previously entered plea. Okay? Can we come back the 19th, October 19th?
Judge, is it okay just to put on the pretrial docket, the 26th, just as a status of it? Would that be okay with the court?
That's fine.
I have other cases that day, and I'm trying to, is that okay with you? And that will give you some time to think about what you want to do and
Is that
call me?
1024, Your Honor?
1024,
Sorry, I
that's
apologize,
not
1024.
in, that's all right. So we'll continue to 1024.
Okay. And that's all I have. Maybe excuse me.
What number? I don't have a Bullard either with no attorney, that's why.
He shows up on
But he's not on the docket. Is he on somebody's docket? What's the?
benchmark.
Can you give us a number? And who is it?
Stephen.
How do you spell it?
Stephen is S-T-E-V-E-N.
What's the case number?
20 CF.
You can come on up, Mr. Bullard. What is it?
20 CF.
Is the state aware of this case?
Yes, Your Honor, I do have it.
Okay. So, is this a I don't have it
Your
on my,
Honor,
so I don't know what it
You
is.
signed an order to appear for violation of probation or community control.
Okay.
He's alleged
So it's a VOP, so.
technical violations.
Okay. So you do have a right to an attorney with this violation. Do you wish to have an attorney appointed? Is there any discussion on this? I don't know.
I talked to my probation officer this morning, and he explained to me that he had his recommendation was termination of probation and all my fines returned to a civil matter. Is that correct, Mr. Morgan?
Let's let the state kind of just review it for a second.
No, that's not what Mr. Morgan says. The offender admitted to the use of methamphetamine. It would be his recommendation that be subject to increased drug screening, continued supervision with the understanding that any future failures will result in another violation being processed.
Does probation have any input on this?
Your Honor, I can find this out. Mr. Morgan is an officer in our Walden County office and not here.
Says that he previously completed the intake process for COPE, but did not complete an evaluation.
Why don't we do this? Why don't we go ahead and appoint the public defender? You want to have the attorney appointed?
Yes, sir, please.
So we'll appoint the public defender. Let's just go ahead and continue this until, can we do it on the 19th?
Yes, Your Honor.
Okay. On the 19th of October at 9 a.m. Just meet with your attorney and try and figure out, because the probation officer is out of Walton County. So if he were here, we'd ask him, give us your input.
Right,
but
okay.
Because he's not.
I can call him though, right?
I'm sorry?
I can call my probation officer and...
You can call your hold on a second.
Reach out.
Come over and talk with the local probation. They'll give you some direction. But make sure and communicate with your attorney before the 19th. Okay.
Brian Bullard. No, something Bullard. Stephen Bullard.
Going back on our regular docket, Quentin Allen.
20 CF 2839, Charlie.
Quentin Allen, oh, he's an inmate. Is that through Dennis, one of your clients?
Yes, Your Honor. Hey, Ms. Rivers, and I have
You may. This, we're here today on case number 2018 CF 2718. There are issues of competency. There have been several reports that have been filed, and there have been a little bit of conflicting recommendations, and therefore the court feels that it's necessary to have a contested hearing. So we'll have a hearing on December 1st at 2 p.m. And it'll be scheduled for a 2-hour hearing. Okay? Anything else from the state or the defense on this?
No, Your Honor.
Okay, very good. Thank you very much. Robert Brown.
Casey Etheridge for Robert Brown, and he would like to, we're here in 2016 CF 1057. He would like to admit to the allegations in the affidavit and accept the state's offer. It would be for adjudication of guilt, reinstate probation, extend supervision for 6 months beyond the termination date of May 9th of 2023, and all of which will be community control. Monthly urinalysis.
The extension will be, or all of the?
From today forward, it's
Day
community
forward.
control.
Yep. Monthly urinalysis, complete a substance abuse evaluation, any recommended treatment, and there is a suspended sentence of 24 months in the Department of Corrections on this case as well.
Was there already a suspended sentence?
No, Your Honor.
So that's being added as well?
Yes.
Okay, is that?
It's a downward departure. It's a downward departure offer, Your Honor. It is the state's.
Mr. Brown, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
And the defense in agreement as to the score sheet?
Yes, Your Honor.
And this is a downward departure based on negotiated plea?
Yes, Your Honor.
So, Mr. Brown, you heard your attorney state the terms of your plea agreement. Is that your understanding of what the plea agreement is? I see that you've signed a plea and sentencing, a written plea and sentencing agreement that outlines this. Have you gone over this agreement and all the ramifications with your attorney, had all your legal questions answered? Because there's quite a bit to this. There's an adjudication of guilt. They're reinstating probation. They're extending it for 6 months, and all of the probation is now going to be community control. And you understand community control. I don't like that term. I like the kind of colloquial term, house arrest.
Yeah.
Because that's a better description for it, really. That's what it is. Okay? It's not like there's curfew. It's like, no, you can't, it's house arrest. If you're going on a job or you got, something that's approved by the probation, that's one thing. But other than that, and, obviously, I'm just going to go ahead and say it. I wouldn't normally put it in these terms. But basically, they're trying to protect you from yourself at this point, okay? Because you're right on the edge of having to serve in DOC. And they're trying to keep that from happening. So you need to, obviously cooperate with regards to the UAs. And this substance abuse evaluation, has that already taken place?
Your Honor, he originally completed a substance abuse evaluation, but that was.
Long time.
For 6 years. For 5 years at least. And he has done one, but he needs to do another one.
Okay. And look, we're all in this system. We understand that it's easy for us to sit up here and talk about substance abuse and all this stuff. It's hard, a little harder when you're trying to deal with addiction, okay? But don't give up, and you need to fight through this, because at the end of the day, it's your inner, I want to, inside, that's going to be the difference. If you don't have that, you got no chance, okay? So you need to be tough and try and fight through this. This is the biggest battle you got.
Will.
Are you willing to do that?
Yes, sir.
Okay. And you understand there is a suspended 24-month sentence that if you don't fail on this one, you're going to have to spend some time in DOC. You understand that?
I understand.
Okay. Very good. Based upon that, the court will accept your, and you understand this is the final resolution of your case, and you're waiving some valuable right. Okay. Based upon the testimony and answers to your question in the plea and sentencing agreement, the court will accept the plea and sentencing agreement, and there'll be an adjudication of guilt, the extension for 6 months with, you'll be on community control for the entire period of the probationary period. And you'll also have to do the substance abuse evaluation, et cetera, and the 24-month suspended sentence. Okay, good luck. Corporal Letty?
Casey Etheridge from Mr. Corpoletti. We're here in 20 CF 449. If I may have one moment, Your Honor. Okay. Your Honor, if we could pass him for a few minutes, Your Honor. Just hold him here, please.
Okay. Darrow? Michael Darrow.
Casey Etheridge for Michael Darrow. We're here in 2021 CF 2001. May I have one moment?
You may.
No, not yours. Do 1129 or you do Keaton? Okay. I think it's, okay. Let's see what his allegation. It's 2 failed drug tests. Nope.
Okay. All right. If we could pass him for a few minutes, Your Honor, so I can go talk to him again. Thank you.
David Fiducia.
Michelle. Can you handle that one? I can't handle that. Sure. Darrow, Michael Darrow.
In just a few minutes, we'll probably take a morning break, and you can meet with a couple of these.
Okay. Yeah. Okay. Okay. We're here on David Fiducia, 2021 CF 667 and 2021 CF 1433. And we'd be entering a denial for today and asking to set this for the next VOP date. I think 11/2 is probably the more appropriate one.
I would agree.
Denial will come back 11/2 at 9 a.m. Sonny Findlay.
Your Honor, that matter is set for a restitution hearing. The victims have just provided me with some bills. I'm going through them, and I'll need to show them to to defense, so I would ask if we could just do that last for this morning.
Okay, so we'll pass on that for this morning.
Restitution hearing. Okay. You'll come back in. Yeah, just go ahead and come back in. Thank you, Your Honor.
John Fleming.
Casey Etheridge for John Fleming. And Your Honor, we'd be asking to set this for the pretrial conference. We'd be entering a plea of not guilty. This was continued from the plea day because he was in quarantine last time, so.
So this is a plea, this is not a VOP?
No.
Okay. Very good. So we'll enter not guilty. You want to just come back on a general pretrial?
Yes.
That would be 11/26, excuse me, 10/26.
Okay. Your Honor, he's changed his mind and he would like to accept the state's offer. Sorry.
Okay.
Okay.
You need to, okay.
And Your Honor, the state's offer is for count 1, adjudication of guilt, 12 months of probation, cost supervision waived, $767 in court costs, $100 cost of prosecution, $150 in public defender fees. It must complete the batterer's intervention program. And then count 2, adjudication withheld, 12 months of probation concurrent with count 1.
What about count 2?
His adjudication would be
Adjudicate-
withheld.
Withheld.
Would be 12 months of probation concurrent.
Okay. Mr. Fleming, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement. Adjudication of guilt on the domestic violence charge, withhold on the count number 2. Both of those would be 12 months of probation. Some additional important requirements, take the BIP program. Do you understand all that? Is that
Yes,
your
sir.
understanding of what the plea agreement is?
Yes, sir.
I see that you've signed the plea and sentencing agreement. Did you go over this plea and sentencing agreement with your attorney? Had all your legal questions answered?
Yes, sir.
Just want to make sure the purpose of these questions is to make sure, 1, you understand what the agreement is, and 2, that you're entering it freely and voluntarily. Okay? So, based upon that, do you have any questions regarding what all this means to you from a legal standpoint?
Yes, sir.
And you're entering into this freely and voluntarily? And you understand that by entering into this plea, it's the final resolution of your case, waiving the right to go to a trial and to contest and all this?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea, and the court will have an adjudication of guilt on the battery charge, 12 months probation with cost and fees. You also must complete the batterer's intervention program. And that's a lengthy program, so you need to get that thing signed up for. If not, you wait 6 months to sign up for it, or even wait 3 or 4 months, you're probably going to be bumping in where you're not going to be able to complete it within the 12 months.
Yes, sir.
So you need to jump on that, okay? Very good. Any questions? Okay, thank you very much. The state, the defense in agreement on the score sheet?
Yes, Your Honor.
Thank you. Wesson Fuqua. Fuqua. Fuqua Wesson. Candy Lee Fuqua Wesson.
Your Honor, Tim Gibbs on behalf of Ms. Candy Fuquay Wesson in 22 CF 2371, 22 CF 2372, 19 CF 2062, and 19 CF 3185. Your Honor, she's on this morning, I believe, for VOP arraignment, as well as this afternoon for arraignment on those two new cases. We'd like to enter denials and not guilty pleas as applicable on these cases and set this for October 26th.
What is this afternoon's, what number are we at?
This afternoon, that would be case number 22 CF 2371.
And what, do you know what number it is?
What number on the docket?
I'm trying to keep up with all this. I don't have it on my plea docket.
Actually, Your Honor, it is set for November 2nd for arraignment.
Okay.
Yeah, she's got two cases set for arraignment on November 2nd.
Right.
That would be 22 CF 2371, 22 CF
Why don't we go ahead,
2372.
we'll enter a denial on this, and
Yes.
we'll come back on that same date, we'll run them together.
Okay, I was hoping we could try to set this on 26 for a pretrial for the new cases as well.
The state has no objection.
Entering so what's the case numbers again, the other two?
So it is.
The one today is 19 CF 2062, what are the other two?
And then you've got 19 CF 3185.
So she's under two names on the docket, Judge. She's under, on one case on 2062, she's under Fuquay Wesson, Fuquay being her last name in that case. In 19 CF 3185, her last name is Wesson, not Fuquay Wesson. So she's on your docket twice this morning because of how those cases were entered, either by law enforcement or by the clerk.
If somebody can show me where they're at, I can't find them. The 39, Marty?
Yes.
That's correct, Judge.
Yes.
I don't have page 14. Would you print off page 14? I don't know why I don't have my docket today. What is it? Let's see. 3186. Is that 85 or 86? Okay. So we want to enter not guilty on the other two?
If we could, Your Honor, and leave everything set for October 26th.
October 26th is our regular pretrial.
Yes, Judge.
Madam Clerk, did you get that?
Yes, sir.
Thank you.
Okay, thank you very much. Okay, Joseph Gainey. After this case, we'll take our morning break.
Your Honor, Joseph Gainey, 18 CF 1032. This is a violation of his conditional release. This is not a violation of probation.
Okay.
I guess we move to dismiss the affidavit, or whatever was not filed.
I'm sorry, I'm confused. We've got three cases before today.
One of them is which one do you have?
One of them is a VOP on the curfew. This is the only one he has probation on. It's 2018 CL 408.
That's the VOP. There's two other cases.
408, he's actually, there was a probation to follow.
No, probation is saying that there's 3 cases, and they're
Right.
saying that 2 of them are conditional release, but they're saying that 18 CF 1032 is not a conditional release.
That's a VOP.
18 CF 408, right?
408.
408, okay.
Okay, I'm just writing on that. So 18 CF
Okay.
408.
18 CF 408 is a VOP.
Is a VOP, and the other ones should be closed.
The other ones are handled by the Florida on Offender Review Parole Commission.
Is there a VOP that's been filed in those 2 cases? Why is it on the docket?
I think it got filed as a group, but 2 of those are on conditional release and
Okay,
not
so
supervision.
18 CF 1032 and 18 CF 2919 should not be on the docket.
That's correct.
So we're not dealing with those.
That's correct.
The VOP 218 CF 408,
Okay.
That is correct.
denial?
Yes,
Or-
we don't have any information yet on this, Your
Okay,
Honor,
so
yeah.
court will enter a denial, and we'll come back on 11/2 at 9 a.m. Trying to figure out where we're going at that point.
And you said 11/2, Your Honor?
Yes, ma'am.
Okay, thank you. Okay.
Okay, well, I'm getting ready to take a break, Miss Dudley. So we'll come back, let's go ahead and take a 10-minute break here for this morning, and then we'll come back.
All rise.
10:19.
Yep.
Sure, that's fine. That's fine. Whatever you want to do.
I'll use one of mine this week.
Sure.
What's he on for, just possession or MSMD?
Okay. So we'll continue with Michael Gray.
It's not us.
He's actually a personal friend, so.
KCS is for Michael Gray. We're here in 22 CF 2248. May I have one moment, Your Honor? He would like to enter a no contest plea and accept the state's offer. It's for adjudication of guilt, 4 months in county jail with credit for all time served, $415 in court costs, $100 cost of prosecution, $150 in public defender fees, $999 in restitution to Lowe's at 4405 Legendary Drive in Destin, joint and several with the co-defendants. And it would be reduced to judgment, and then he would get credit since arrested in Shelby County, Alabama on August 8th of 2022. Yes, yes, yep.
That's more than 4 months, right?
What?
Say Shelby, since he was arrested?
Shelby County, in August 8th, Your Honor, so it's not been 4 months yet. I mean,
August 8th.
August 8th, yeah. You sign your name there, yeah.
The stated agreement.
Yes, Your Honor.
Mr. Gray, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Just want to make sure you understand what you're pleading to and that it's free and voluntary. So you heard the attorney state the terms of your plea agreement. Is that your understanding what the plea agreement is, and are you in agreement with that? Okay. And I see that you've just signed the plea and sentencing agreement, the written plea and sentencing agreement. Have you gone over that? Have you read it and gone over it with your attorney?
Yes, sir.
Made sure you had all your legal questions answered about the plea agreement? Do you have any other questions? Okay. And so, obviously, the core of this is the 4 months in the county jail. You will get credit for all time served, beginning with your arrest in Shelby County, Alabama on August 8th, 2022. That's when your credit for time served will start. There is restitution that's involved. Now, it does not say it's going to reduce to judgment. Okay, it does say that. Okay. So it's joint and several. Do you understand what that means, joint and several? So the $999, you got, somebody paid it before the other. It's only, if somebody else pays part of it, you have to pay the other part of it. It's basically, you're all joint. You jointly owe it, okay? So the main thing is that it gets paid. So, and you understand that by entering this plea agreement, you're waiving the right to go to a trial. This is the final adjudication of your case. Okay, very good. Based upon your testimony, the court will accept your plea agreement. It'll be an adjudication of guilt, 4 months in the county jail for credit for time served, as well as the fees and costs that are contained in the plea and sentencing agreement. Is the defense in agreement with regards to the score sheet?
Yes, Your Honor.
Any questions, sir? Thank you. Kenny Harrington. Oh, you want to do yours, Miss Dudley? Let's go ahead and, David Cornell, let's do Miss Dudley's cases.
Good morning, Your Honor. This is David Cornell in 22 CF 2224. We have filed a motion to unseal the search warrant. I believe the state is objecting to that request.
Okay. The court has reviewed the. Hold on a second. I reviewed it before. What's the state's position?
Your Honor, the state would object to unsealing the search warrant. The defense has a burden of showing a specific reason why disclosure of sensitive information contained in a sealed affidavit is necessary.
That's right, that is our burden once the state shows what sensitive information is. If
No.
it is the
One at a time, one at a time.
If it is the confidential informant's name, then that can be redacted. It's my understanding the state has not even reviewed the search warrant. So how do we know it can't be redacted to the point where we can see the affidavit?
The court found it necessary to seal it to begin with. The state must reveal information about a confidential informant only when it shows a specific disclosure is necessary for specific defense. A bare allegation that defense counsel cannot prepare a defense without the information in a sealed search warrant affidavit that contains potentially sensitive information exempt from disclosure is exempt from disclosure under the discovery rule. It is not enough to require the state to unseal any affidavit.
And I truly understand that. But
And that's as Hill v. State, Your Honor. It's 307 Southern
So
3rd.
wait. I know we got a bunch of cases, but we
I got it.
Hold on a second, let me pull up. I was reviewing the motion before, but. Do you have the order sealing the warrant? What date that was, so I can look at it?
No, Your
In other words,
Honor.
was there any findings regarding?
It's
why it
not
was
filed
sealed?
in the case, Your Honor.
Is it supposed to be?
The defense requested it, law enforcement said it was sealed, that's all we know.
If I understand the process correctly, Your Honor, they have to apply to have it sealed. A court has to find that it is necessary, and once they sign off on it and it is sealed, then it then
Is
becomes
that-
the...
Did that happen? That's
For
that's
them-
my question.
Well, for them to say that it is sealed,
No.
We have not seen an order, Your Honor.
No,
That's that
it's
question.
got to be in the court file, or somebody's got to show it to me. You're saying that I took some action that I'm just not aware of. Maybe I did. I don't know.
let's see.
And if the state's uncomfortable answering this question, you can object to it, but I mean, are we dealing with an informant? Is that the issue? Okay.
Yeah, and I would point out, the offense report talks about confidential informant within the offense report. It talks about cooperating defendant. It talks about all those things within the offense report, which that's been given to the defense.
I'm sorry, the offense report has been?
Yes, and it
Okay.
talks about confidential informants in it. It talks about cooperating defendant. It talks about that information in here. I believe what the state mentioned to me was that the information would lead to the discovery of the CI. The case is a search warrant.
CI?
Yeah, to the confidential informant. Sorry, Your Honor. While the state's saying this stuff they can't redact, my position is, how does the state know that it can't be redacted? To where the confidential informant's name can't be removed and we still be able to get it without them reviewing it? Because they haven't reviewed it at this point. Legally, we have a right to it. I know we don't have a right to confidential informant's name, absolutely. They're not a party to the case, they're not needed in this case. So I know we're not entitled to their name. Not entitled to know who they are, absolutely. But part of this mostly deals with the confidential, actually cooperating defendant, not a confidential informant, is what they state in the offense report. They have confidential sources listed, but not really as far as any drug transaction, just information they gave. Not really as far as they bought drugs or things like that, just general information that was given. If that's given, that would not lead to the discovery of a confidential informant if they just say, this stuff happens at this house. It's more, what we're looking at is we're entitled under any documents related to search and seizure, and we're not entitled to a confidential informant. But if the state can review it and look at it, because in Hill v. State, the state argued it couldn't be redacted. But in this situation.
My first question is, I want to understand why it was sealed.
We don't usually see an order. All we do is ask the state. The state tells us the law enforcement says it's sealed. There has not been an order.
It's not something that requires court action.
It does require court action. We just have not seen the order that they say they received.
Well, if the court's not aware of action, and I don't do anything that doesn't make its way into the court file. I take no action. I don't take an extrajudicial action outside of the court file like this. So if it's not, maybe it's not normally done, but if it's contested, now you gotta.
And Your Honor, it doesn't mean that you did it. It could have been another judge that did it. I think probably the best solution here would be to have the officer come in and present testimony as to who he presented it to and who signed off on it.
Signed off on what? The
seal? To seal it, yes, sir.
I think the best solution would be to provide the order that the court signed. And we can go from there.
Provide what order?
If he signed the order, if they sealed it, wouldn't it be an order sealing the search warrant? How else would we know it was sealed?
Agree.
I mean, it's not just something, hey, we sealed it. It's not just something that's out in the ether. It's got to be something that was done.
Yeah, if there's some kind of documentation, exactly, and I believe that Mr. Richards would be the one to provide that information.
Okay.
Since he is the one that applied for it, it looks like.
Okay, so it seems to me that we've got some outstanding information that we need before the court can make a decision.
Yes,
So
sir.
why don't we continue this, just essentially a motion hearing,
Yes, sir.
and come back. Can we do it on the 19th of October?
Good.
Is that,
What time? Is it afternoon? I have depots all morning.
we can do it in the afternoon. Because we may need to take a few minutes anyway, so.
Yes, sir. What time, Your Honor?
2 o'clock.
2 o'clock. Okay.
Thank you for giving me this case. So I'm going to give it back to you because you may have to give it to me again. I was going to be asking for that case law, and if there's any case law that you need to do it, just this is something that's a little bit out of the ordinary. I want to make sure and make a good call.
Yes, sir.
Okay. So continue to. Okay. Cordell Thomas, another case. attorney. Is Amos Washington here? That was the number one, it was at 11.
She's like 36 months with all credit, or 24 months with no credit till the rest.
Okay, we'll do that after.
So she said if she didn't have it written down, just to continue it until she gets back. Yep.
What? I'm gonna continue. I can't get an offer. I can't get an agreement. So.
Where are we at?
And we're gonna have to continue until the prosecutor who's on the case is present.
Okay. Why don't we come back October 19th?
Can we
Your
do
Honor,
that?
she's not back until November 2nd.
November 2nd at 9 a.m.
Yes, sir. Your Honor, I had Krista Spears on the docket, but we can just remove that motion because she was released from
Okay.
jail.
Very good. I think that's your last one, because
Yes, sir.
Mr. Durrell handled the Williams.
Yes, sir.
Okay. Very good. Let's go ahead and do Amos Washington, which was number one. That was just a motion to withdraw. I was going to call the attorney.
Yes, Your Honor.
And are you handling that case?
Yes, Your Honor.
Let me see if I can get.
Hello, good morning.
Good morning. Is this Mr. Buck?
Yes, Your Honor, this is Benjamin Buck.
Okay, this is Judge Ketchel. We're here in open court. You're on a speakerphone, and your client, Mr. Washington, is here present, along, obviously, with the state. This is case number 2021 CF 2413. I believe this is on your motion to withdraw, Mr. Buck?
Yes, Your Honor, this is on my motion to withdraw.
Okay. Anything you need to add to it?
I would just say irreconcilable differences, but I've never seen anything like this, what happened to me by, not to go into too much detail, but by Mr. Washington's family. So I just respectfully, Your Honor, ask to withdraw.
Okay. Mr. Washington, anything you want to?
What happened?
You care to share with what happened, Mr. Buck?
Yes, sir. They fraudulently filed, what they did was they told their banks that I fraudulently charged them for their retainer, which has now caused us to go into an investigation, and I just want no part of this. We've made a criminal referral. It's ridiculous.
Okay. Well, I believe this does create the grounds for irreconcilable differences. The court will grant your motion to withdraw. Okay. You can get me an order, Mr. Buck?
Yes, Your Honor, we will provide you with an order.
Okay. So, Mr. Washington, okay, you're good. I'm going to go ahead and disconnect you, Mr. Buck.
Yes, Your Honor. Have a wonderful day.
Thank you. Okay, so, Mr. Washington, at this point, it means you're without an attorney. I don't know if you qualify for a public defender, but do you wish to have a public defender appointed? You're going to try and hire private counsel?
But they didn't file that until he
said that he was he told them that he was withdrawing from the case.
I mean, I already ruled on that the prior. Becomes difficult once you get crossways with your attorney, you know.
Oh, yeah. I
You
know.
got to be on the same page because they're obviously important to your defense. So the court will appoint the public defender. Are we currently scheduled for a pretrial, Stan? Okay, so you're scheduled on the next cycle, October 26th, 9 a.m., okay? Sure you'll have a chance to meet with your public defender in the interim.
I know, I saw someone.
So we passed over a few in the Let's go out of Yarwood this afternoon's. Then we'll handle yours. We'll handle yours next.
Charles Russell, Public Defender's Office. Judge, this is Bruce Yarwood. Case number is 21 CF 320. It was set for a sentencing hearing this afternoon. Can the state and I approach?
Some details are still trying to be worked out with some of the conditions of the plea agreement and that would result in the sentencing. So the court will continue this until December 1st at 2 p.m. Okay?
Thank you, Judge.
Do you approach? Okay. You want to skip over, you want to get any of the skip over cases, or you want to continue with the
Or
docket?
we can,
Which ones
whichever
do you
one you'd
want?
like to do, Your Honor. We can do the skip overs if you
It's
want.
up to you.
That's fine. Sure.
You want to do the ones that you skipped over?
Sure, that's fine.
Okay, so the ones, let me see where I've got.
So the first one we had, I guess, because it was a no attorney, but an appointment, there's the Delaquila, I think.
Hold on just a second here.
Yeah.
Which one's the first one that we?
Isabella Delaquila. It was a no attorney, but you appointed me today. And we had already known about it, and she was gonna, resolve this case. It's number 11. I believe.
Oh, gotcha. Okay.
We're here in 2020 CF 193. Ms. Delacour would like to admit to the allegations in the affidavit and accept the state's offer. It would be for adjudication of guilt, revoke and terminate probation, 270 days in county jail with credit for all time served, $100 cost of prosecution, $100 in public defender fees, all fees, fines, and court costs reduced to judgment, and it would be concurrent with 2019 CF 79.
Very good. Is the state in agreement?
Yes, Your Honor.
Is the defense in agreement regarding the score sheet?
Yes, Your Honor.
Yes. Thank you.
The score sheet, I'll be fired up.
Okay, that's fine. So, Ms. Delaquila, is that how you pronounce that?
Delaquila, yeah.
Sorry. Delaquila? Okay. Ma'am, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
You heard your attorney state the terms of the plea agreement. Put your hand up.
Yes.
Is that your understanding of what the plea agreement is? Are you in agreement?
Yes.
I see that you've signed the plea and sentencing agreement. Have you gone over this plea and sentencing agreement with your attorney? Make sure you had all your legal questions answered?
I just had one question between like last Thursday. Now they're
Well,
not.
hold on a second. Ask your attorney first. I don't want you to say something in open court
They're
before.
not giving my Seminole County time.
Okay. I think it was addressed in the plea.
I think kind of like what happened with this.
Oh, okay. Well, I mean, it should be that it's concurrent now, but,
I'm sorry, I didn't hear what she said, so I mean, I
She's
just
saying that
didn't
she's
want
not
her to
getting-
say something.
yeah. But she's just saying she wasn't getting credit for when she was in Seminole County waiting for transport. That hasn't been effective on her case yet, which I thought was a part of the plea agreement originally, but I could be.
Because it was like, I was in Seminole County, they let me out on bond.
Right.
But no.
It is running concurrent with 19 CF 79. I don't know what.
Madam Clerk, do you know if that was on the original one? Okay.
On the other plea agreement?
Yeah. Objection to her getting the 47 days from Seminole County.
You in Seminole County for anything else?
No, I got time served.
So you were serving time in Seminole County?
It was
for-
just for like a ticket.
Yes, state has no objection.
Okay. So ma'am, you understand that by entering this plea agreement here today, you're waiving the right to go to a trial. This is the final adjudication of this case?
Yes, sir.
And have you had all your legal questions answered regarding this case?
Yes, sir. Thank you.
You believe you've gotten good legal representative, you've been represented well on this case? You had
Yes,
all your
sir.
legal questions answered? Okay. Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt, revoke and terminate probation. You'll get 270 days in the county jail credit for time served, including the 47 days credit from Seminole County, the arrest there, as well as the fees and costs that are contained in the plea agreement. This will run concurrent with 19 CF 79. And you'll file the sentencing, the score sheet separately.
Yes, sir.
Okay, thank you very much.
And then the next one that we passed is number 23, Robert Carpoletti.
Corporetti?
Yes.
Corporetti?
Corporetti or Capoletti, however you say it. I'm not sure which one. Casey Etheridge for Mr. Capoletti. We're here in 2020 CF 449, and we'd be entering a denial for today and setting this, I guess, for the 11-2, Your Honor.
Is this Gilson's case?
Well, I'm sorry.
Miss Gleason's case as well?
No, it's not.
No, it's not.
Can we set it then for October 19th if we can? We're just trying to
We can, Your
fill
Honor.
that.
We can, Your Honor. I'll try to have, yeah.
Okay, 10/19 at 9 a.m.
Okay.
Michael Darrow. Any luck? If you just get a time, maybe at the very end, maybe at 1 o'clock or something like that, try that.
Yes, that's the last one I skipped, I think.
Give you an opportunity to have some fine Crestview cuisine.
Yes, sir.
That you don't get over in Pensacola.
Sorry?
I said that you don't get over in Pensacola.
I do like Pounders, I think it's the Hawaiian place over there.
Casey Etheridge from Michael Darrow. He would like to enter admit to the allegations in the affidavit and accept the state's offer. It would be for adjudication of guilt, revoke and terminate probation. He would get 9 months in Okaloosa County Jail with credit for all time served, $100 cost of prosecution, $150 in public defender fees, and all fees, fines, and court costs reduced to judgment. Got it? That's fine.
The stating agreement.
Yes, Your Honor.
Darrell, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Thank you. You heard your attorney state the terms of the plea agreement. Is that your understanding of what the plea agreement is, and are you in agreement? Okay, you can put your hand in. So, you understand that by entering this plea agreement, you're waiving the right to go to a trial, and this will be a final resolution of this violation of probation. Is that, you understand that? I see you've signed the plea and sentencing agreement. Have you gone over this plea and sentencing agreement with your attorney? It states the terms of the agreement. There's some other stuff in there. Have you read it? Have you gone over it with your attorney? Okay. I just want to make sure you've had all your legal questions answered regarding this plea agreement, because it does contain 9 months in jail. Just want to make sure that you understand what you're doing and that you're entering it freely and voluntarily. Okay. You will get credit for time served, okay? And there'll be some other fees and costs. So, do you have any further questions regarding this plea agreement we have today? Okay, and you believe it's in your best interest to enter into this plea agreement? Is the defense in agreement regarding the score sheet?
Yes, Your Honor.
Based upon that testimony here today, the court will accept the plea agreement, revoke and terminate probation, sentence the defendant to 9 months county jail, credit for all time served, fees and costs as contained in the plea agreement. Okay. Thank you very much. Are we ready on Sonny Finlay with the restitution issue? I don't know if we,
Your Honor, we
If
could
you'd
do
like
it
to.
now, but I think the court will be somewhat frustrated. There's not totals that the victims have provided, just they have submitted a bunch of documents, and that's what I'm going through.
I mean, it's your obligation to prove it, so. Do we need to come back later and?
Okay.
Now, this appears legit.
Okay.
So,
Okay.
just have y'all look at it.
Okay. If we could just pass that till the end, Your Honor, I would really
Okay.
appreciate it.
Just remind me of it. Counsel for the state, just wave at me if you figure out something. I'm just kind of, okay. I think the next one on mine is Kenny Harrington.
Yes. Yes. Casey Etheridge for Kenny Harrington. We're here in 22 CF 874. And Your Honor, we'd like to set this for the October 19th docket for resolution.
Very good. So we're enter a denial. We'll come
Yes.
back on 10/19 at 9 a.m. John Russell, Harvard.
Harvard.
Your Honor, Casey Etheridge for Mr. Harvard. We're here in 22 CF 1810, and we're here for a bond hearing, I believe it is.
Okay.
Okay, and it's a motion to reduce bond. His bond is currently set at $120,000.
What is that? How's that broken down?
Hold on. Apologize, Your Honor. There was a mental health evaluation done, so it's kind of, there's several first appearance things. Let's see. Sir. Okay, here it is, Your Honor. So it's looks like it's 50,000 on the aggravated assault, and 10,000 on the carrying a weapon openly, 50,000 on a weapons offense. So it's like use of a firearm during a felony, and then 10,000 for possession of a weapon by a convicted felon.
What's the defense's request and what's your argument?
Sir, I'd like to take testimony from Mr. Harvard, Your Honor.
Would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, slide that thing over the speaker so I can make sure and hear you.
Okay. Or Mr. Harvard, the So we're here asking for a bond reduction because you can't afford the amount that's
No,
set.
ma'am, I can't,
Okay, let me ask you questions. Okay, so you can't afford it, right?
no, ma'am, I sure
Okay.
can't.
Okay, can you tell the judge about your medical history that you have going on right now?
Yes, sir, I have liver cancer, Your Honor. I've been in the hospital twice since I've been incarcerated. I have a ruptured, strangulated hernia on my right. I have COPD, but, excuse me, sir, but not to be disrespectful to your court, my liver right now is thumping like a drum. I have hospice. I had hospice at the house coming out 5 days a week. Me and my wife, we've been together for about 30 years at the end of Spruce Lane off of Mount Olive Road. By me being in here, I'm gonna have to, if I can get out, I'm not going nowhere. I've been here for all my life. I'm no threat. I'm not a violent person. I've been in trouble in 15 years. I just need to get out where I can get some medical attention where I could spend what little time I have left with my grandchildren, sir.
And how much of a bond would you be able to afford?
Like I said, I could borrow $1,500, you know, and then, you know, that would wipe out what I had saved up for my Christmas. I could report every day if you know, every Wednesday or whatever, however, even my wife, you know, said she would sign for me. I've been in the hospital, sir, twice since I've been, like I said, incarcerated.
Nothing further, Your Honor, as far as testimony.
Your Honor, if I may. Sir, do you have any documentation to present about having cancer?
Yes, ma'am, you can get in touch with Dr. Wall with Regency Hospice.
So you
I
don't
don't
have
have
it-
nothing with me, no
Okay.
ma'am.
All right.
My wife, you can call her and she'll verify it.
And you're not wearing the colors, the medical colors for the county jail, are you?
No, ma'am, I'm in special housing because of the medication.
They're not putting you in white?
No, ma'am, I done been through that twice.
And he is on the jail list in special housing.
Like I said, I live off of Mount, I'm not going nowhere, and I will be at every appointment.
I don't have anything further.
Anything else?
No, Your Honor, we just asked for a bond reduction that Mr. Harvard can afford so he can get the medical attention that he needs.
Arguments? I mean, you kind of just stated.
Yeah, I mean, that's what my argument is.
Your Honor, these are very serious charges. Aggravated assault with threat with a deadly weapon. He did allegedly pull a gun on someone and threaten to kill them. He is also charged, as you'd already heard, with the possessions of a firearm by convicted felon, possession of firearm during the commission of a felony, and battery. Your Honor, he had mentioned he's not a violent man. I do show that there is an old conviction for aggravated battery. He does have, let's see, he has a prior failure to appear, and then numerous other various felonies. State believes that the bond is sufficient. And there's been no testimony that he hasn't been able to get treatment while he was in the county jail. And I believe that is an important factor. We all know that if there is an issue, the jail doesn't hesitate to reach out and contact the state and/or defense saying, look, this person requires more attention than we can give them. We have to take them to the hospital more than we have staff for. We haven't heard any of that today, so it's the state's position that they must be able to sufficiently take care of him because we haven't heard anything to the contrary.
Ms. Etheridge, anything further?
Nothing further at this time, Your Honor.
Mr. Mr. Harvard, I understand your medical condition, but these are very serious charges, and with all
Yes,
due
sir.
respect, I think you are a danger, and that's why you've had an arrest on multiple charges, including possession of a firearm by a felon. So you well know that you aren't supposed to even have a firearm within shouting distance of you, and that is one of the charges, and there's been probable cause found on it. I don't believe these bonds are inappropriate. I know they're hefty, but they're not inappropriate. The court's going to deny the motion on the bond hearing.
Your Honor. And he's already set for October 26th, Your Honor.
Very good.
I'm allowed to, protect myself.
Don't talk about that.
So I don't have a bond.
You have a bond, but it's still the same.
I place it.
William Talbot.
Your Honor, Tim Gibbs on behalf of William Talbot. He's here this morning on 20 CF 2925. He also has 22 CF 2507 and 22 CF 2508.
Is that on this afternoon?
I believe it's on this afternoon. If not, it's on for 11/2.
Hold on a second. I just want to make sure we don't.
Right.
I don't have them on today.
Okay. But we do have the VOP. He'd like to enter denial. And I guess we can either put him on pretrial for 1026 if we do a not guilty on the other two new laws, or leave this, track this with the new law on its plea day on 11/2, if that's what the court would like to do.
Is it, he's got 11/2 plea day?
I believe that would be his plea day on the two new law violations, and the clerk is indicating yes.
Okay, so why don't we go ahead and enter a denial, and we'll track this one on 11/2 as well.
Very well.
Monica Simmons.
Do you have both of these? Yeah, here.
No, she said that Richard hadn't given one yet.
I thought it was filed in the court file. The only difference really. But as Richard says, she should be.
Yep.
I'll ask her about it, I assume. Thank you. Ms. Etheridge, on Ryan James, that was one, there were a couple of cases. Ms. Flowers had one. Did we resolve everything?
No, Your Honor, and last time we had court with Judge Gonteric, they thought that Ms. Etheridge had filed a motion, and she indicated she did not. And then there was a discussion about Ms. Flowers filing a motion, but Ms. Flowers had not, and that Ms. Flowers was waiting until depositions, which are set for next week, before she proceeded on a potential bond motion. And
So should we just continue this?
Yes, it should just be set for the pretrial conference date, Your Honor.
So we'll continue, this is case number 22 CF 1883, continue to
1026, Your Honor. Yep.
1026.
No. Yeah, and Ms. Flowers already went and talked to him again about the bond hearing, so.
Okay, because he's incarcerated, but we'll bring him over. So is Ms. Simmons being brought up?
Well, I believe we're waiting on her right now, Judge. She's getting, I think they're getting her now. Simmons, yes. Your Honor, this is Ms. Monica Simmons, 19 CF 1523, 20 CF 1854. Tim Gibbs on behalf of Ms. Simmons. Your Honor, she's set for a competency hearing this morning. We have received reports from Dr. McDonald as well as Dr. Pritchard. Both of them believe that have opined that Ms. Simmons is incompetent to proceed. Dr. Pritchard is recommending that she be committed to Department of Children and Families, to the state hospital for competency restoration services. I have no objection to admitting those reports as well as that recommendation.
State in agreement?
Yes, Your Honor.
Very good. Based upon let's go ahead and file. We not filed those reports?
I have them if the court does need them to file.
Have they been filed?
I can present those to the court this morning.
Thank you. So based on the evaluations by Dr. Pritchard and Dr. McDonald, the court will find the defendant incompetent to proceed and order the competency restoration and allow her to be at the state hospital. And we should come back in 6 months. We should put it.
You want a status in 6 months, Your Honor?
Status in 6 months. Madam Clerk, can you give me and we'll file these two, Madam Clerk.
I know some people don't have to be there.
Just to check in if we need it. I'm sorry?
March 2nd, 2023.
That'll work. So right now you're reset for that date as a status if we need to come back.
Okay, good luck. Roberto Solis.
Your Honor, we're going to have to continue that. I did initially sign that, but as it was noticed, I was the original attorney on the case, therefore I cannot have any part in violation of probation or any part of the case. So we will need to continue that until 11/2. It doesn't affect his getting out anyways.
Can we do 10/19?
Nope, she's not here.
We can't borrow anybody else? Sorry. Eleven two is fine, Your Honor.
Okay.
Yeah, I'll have you sign it before then. We'll get it done as soon as we can. Yeah, no problem. Yeah, I'll come have you sign it.
We'll continue this till 11/2 at 9 a.m.
Perfect. Thank you, Judge. Yeah, we'll get it done then.
Dorinda Steinman.
So excited to get that one.
Yeah, he noticed it.
We can't borrow Paul's. We can't use it.
Yeah, you could ask him if he wants to do it, but
If he's willing to sign for it.
Yeah.
Do they sign? It should be on page 4.
Yep.
Your Honor, this is Ms. Dorinda Steinman, 22 CF 1071, if I can approach.
You may.
Written plea score sheet, Your Honor.
Thank you.
This is an urban plea or change of plea hearing. She's being put on, she's receiving a withhold of adjudication on the possession charge, adjudicate on the paraphernalia charge, 6 months of probation with standard court costs, $100 cost of prosecution, $150 PD fee, substance abuse evaluation, treatment if recommended, subject to random UAs, no drugs or alcohol without a valid prescription, as well as 15 hours of community service.
Okay, Ms. Steinman, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
4,002.
You hear your attorney state the terms of the plea agreement?
Yes, sir.
And I see that you have signed the written plea and sentencing agreement that also contains those.
Yes, sir.
Have you gone over this agreement with your attorney, this plea agreement?
Yes, sir.
Made sure you had all your legal questions answered.
Yes,
Just want to
sir.
make sure you understand what you're doing and you're entering into this voluntarily. That's my purpose of my questions. So, you understand that by entering into this plea, you're waiving the right to go to a trial.
Yes,
You're
sir.
waiving the right to confront witnesses. These are some
I do.
valuable legal rights that, I have to make sure you understand that you're waiving.
Yes, sir, I do.
Okay, and you're satisfied with your representation on this?
Yes.
Okay. Based upon that testimony, the court will accept the plea agreement. There'll be a withhold of adjudication on the possession charge, possession of cocaine, 6 months probation, the cost and fees, the substance abuse and evaluation. That's maybe the most important thing that's in this.
Yes, sir.
And you need to get on that right away because you only got 6 months probation.
Yes, sir.
So you can start that, and we don't want you to violate your probation because you can't do it.
Yes, sir. I'm going to go
Also-
as soon as I go to probation. I'm going straight there.
So no drugs or alcohol, and there'll be an adjudication of guilt, credit for time served on the possession of paraphernalia.
Okay.
Okay.
Thank you.
Very good, thank you. And the defense is in agreement on the score sheet?
No objection to the score sheet, Judge.
Okay. Thomas. Jarvelis Thomas. You just stand at the podium, sir.
Oh, yep.
Your Honor, this is Mr. Jarvelis Thomas, present before the court on VOPs in 19 CF 2582, 19 CF 2598, 19 CF 2663. Tim Gibbs on behalf of Mr. Thomas. We're going to ask to continue this to November, or enter denial and continue this to November 2nd to try to get this resolved.
So this is a Glisson case as well?
Yes, Your Honor.
11, 2, and 9 o'clock. Jeffrey Willis.
Emailing her to try to see if we got done. November 2nd.
Please, would you approach?
Jeffrey Willis in 22 CF 1565. Tim Gibbs on behalf of Mr. Willis. We had filed a competency evaluation with the court. I believe the state has asked the court to appoint an expert for a second evaluation on Mr. Willis for competency. We have no objection to that. And then otherwise, I believe we need to set him for November 2nd to await that report.
Well, you think the report will be done by November 2nd?
No, perhaps not. I don't remember which expert the state was appointing.
Your Honor,
Or wanted
according to my
appointed.
notes here, it says Dr. McDonald. So I would recommend at least 2 months.
So December 1st.
That's sufficient, Judge.
Okay. So the court will order the second competency evaluation. We'll come back December 1st at 9 a.m.
Make her report.
Rochelle Wilson.
Your Honor, I believe she is out of custody. I called her name this morning. I did not receive a response on Ms. Wilson, so I do not believe that she is present.
State.
Your Honor, the state would request a case.
Court will order Capias for failure to appear. Dylan Martin.
And
I'm sorry?
Is there a bond for?
No, it's a no bond at this point.
And I believe I did have a Jonathan Wilkinson on today's docket as well as this afternoon's docket. I don't know if the court
I do have, there's an add-on for Jonathan Wilkins. You want to
Okay,
do that
well-
one first?
It's a plea, Judge. I'd like to go ahead and resolve him if we can.
Did you say this afternoon he was on?
He was on for plea day this afternoon. We had actually filed a bond motion. However, we've been able to resolve the case, if I may approach.
Okay. Thank you.
Does this one have a second page in it?
Your Honor, as the written plea indicates, Mr. Wilkinson is going to enter a plea of no contest this morning. The state will dismiss count 1, which is the felony possession charge. He would be adjudicated on a possession of paraphernalia, the misdemeanor, receiving an adjudication of guilt, credit for time served, standard court costs, which I believe are $270 or $220, cost of prosecution, which I think is $100, as well as the cost of defense that would be due. We would ask for in 180 days.
So payable in 180 days or cost to collections?
Collections or judgment, Judge,
Okay,
yes.
so I'm going to ask you to
I can certainly write that down.
put that on there. Mr. Wilkinson, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement. Is that your understanding of what the plea agreement is? And
Yes,
are
sir.
you in agreement with that?
Yes, sir, I am.
I see that you've signed the plea and sentencing agreement that not only contains the terms, but also has some kind of boilerplate information, important, but regular, boilerplate. Have you been able to go over this plea and sentencing agreement with
Hey,
your
run over in
attorney?
full,
Make
yes.
sure you had all your legal questions answered?
We did.
And you believe it's in your best interest to enter into this plea here today?
I do.
Okay. And you understand this is the final resolution of your case?
Yes, sir.
You're waiving the right to go to a trial, et cetera. Very good. Based upon that testimony, the state's in agreement with this? Ms. Rivers, state's in agreement?
Yes, Your Honor.
Based upon that testimony, and the defense is okay with the score sheet?
Yes, no objection. Well, it wouldn't be needed at this point since it's a misdemeanor, but we still submitted it.
That's true. Okay. Based upon that, the court will accept your plea agreement. Mr. Wilkinson, the court will accept the null pros of the possession of a controlled substance. You will get an adjudication of guilt as to the possession of paraphernalia. You will get credit for time served, standard court costs and fees. You get 180 days to pay or it'll go to collections.
Yes, sir.
Thank you, Your Honor.
Thank you.
Thank you.
Good luck.
Thank you very much.
Dylan Martin.
Charles Russell, Public Defender's Office. Judge, this is Dylan Martin. Case number is 20 CF 432. Mr. Martin is before the court on a violation of probation. This time we're going to enter a denial. We would ask for the November 2nd court date because it'll be Ms. Glisson's case.
Very good. The
No, it's
court-
not Miss Glisson's case, it's my case.
Okay.
Okay.
So can we do it on the 19th? Just,
You want to?
We can
Okay.
try.
Are we doing it at 9 or 1?
9 o'clock,
9 o'clock, no subpoenas.
then 19, 9 o'clock.
Okay.
Very good, thank you. Mr. Russell, while we got you on another case, I know Ms. Bassau's not here, and you guys may not have any information, but have you all had any conversations, wanted to do in open court, any conversations? You know, we were trying to go out of cycle to do that 2-day trial with Miller, that whether, we had to continue it last time, and by the way, it's good to see you. You don't look worse for the wear, but
I just pulled
glad
them
to
up.
see you're moving well, et cetera.
Yes, sir.
I was just wondering whether there had been there was some discussion, because everyone kind of wanted to get it done.
Right.
And I had a little time because of a civil jury trial. It looked like we had a couple days, the second week of the jury trial week, on Thursday and Friday.
What dates were you looking at? I thought I'd heard October 20th and 21st. Does that sound right? If those were the dates,
Sorry, I
Judge.
don't know why I'm not asking you this, and here we go. I got it. Yes, it would be the 20th and 21st, Thursday and Friday of October.
My wife and I have plans to go out of town those days and come back Sunday, so I would
You
not.
don't want
be
to
able-
say that in open court, Mr. Russell. You say you have a conflict.
I have a conflict, Judge.
Okay, that's a very important conflict. We try not to. Okay,
He needs a vacation.
so I'm just going to take that off the calendar, and we'll be on our regular schedule for the pretrial, and we'll go from there and try and get it on. You know, I know it's a priority for the
Yes, sir.
next cycle as far as trying to go.
Okay.
We'll try
That'll
and
work,
get it
Judge.
done in November.
Yes, sir.
Okay. So, McKinney, Hunter McKinney.
Charles Russell, Public Defender's Office. Judge, this is Hunter McKinney. Case number is 22 CF 2148. Mr. McKinney was passed from last week because he was in quarantine, so this is actually his felony plea day. This time, we're going to enter a plea of not guilty, ask for a jury trial, and 15 days to file any pre-arraignment motions. We'd ask for the 10/26 pretrial conference date.
I'm sorry, say that again. What date?
10/26, the next pretrial conference
Very
date.
good. Court will enter a not guilty plea, and we will have we'll come back on pretrial on 10/26. Nathan Neighbors.
Charles Russell, Public Defender's Office. Judge, this is Mr. Neighbors. He has case numbers 20 CF 1521 and 21 CF 1272. Mr. Neighbors has a new law violation that's set for felony plea day this afternoon. It's on page 5 of your docket. Case number for that one is 22 CF 2300. What we would like to do today is enter a plea of not guilty on 22 CF 2300, deny the VOPs in the other two cases, and ask that all three cases be set to the 10/26 pretrial conference.
Very good. The court will enter a denial of the VOPs and a not guilty plea on the new law charge. We'll run all these together on 10/26 pretrial at 9 a.m. Ollie Nielsen.
Charles Russell, Public Defender's Office. Ms. Nielsen is present and approaching. Case numbers are 21 CF 386, 21 CF 1726. At this time, on Ms. Nielsen's cases, we're going to enter denial. The state wants to get Ms. Nielsen evaluated for possible rehab, so we're going to ask for the 11-2 docket to give us enough time to get those evaluations done.
The court will enter a denial and we'll come back on 11/2 in the morning at 9 a.m.
Thank you, Judge.
And I think we did Kieran Williams.
You did, Your Honor.
have any, do we have some that we skipped over? Finley, restitution. Any luck?
No judge.
No?
No judge.
Well,
I asked, yes, if a lunch break is coming up, when it's a good time, maybe we can squeeze it in before one or after one.
approach for a second. The restitution, which case is that?
That would be
There it
Sunny
is.
Finley.
Yeah, I got it. Finley, Sunny Finley.
22 CF 191.
I may have one moment, Your Honor.
You may.
They had already established it. This is the amount, that's what they're. So, this state has documentation. Agree to this, and it can be reduced to lien. Okay. Okay, he would like to agree to the amount of restitution that the state has proposed. It's $2,890.63, and then just have it reduced to lien, because, or I guess he has to pay some of it during probation, right? Because he gets probation.
Yes,
afterwards,
yes,
right?
yes,
Let's pay some of it during probation.
yes.
Not yet,
Oh, okay.
not yet.
So, if, my understanding from probation.
This is case number 2022 CF 191, just for the record.
Yes, Your Honor.
Yes, Your Honor. And based on the number of bills and receipts that were submitted by the victims who are in court here today, the amount comes out to $2,890.63. Victims' compensation has paid an additional $210 since you entered your plea. But one of the things I was going to mention is I had gotten a letter from probation, not on this case, but saying that when a restitution is entered, that unless we establish a minimum monthly payment, that they're not required to make any payment until 60 days before their probation terminates. With that understanding, this and knowing that you are still in jail, we would request that the court establish the restitution amount, give him at least 60 days upon release to obtain a job, and then make monthly payments of a month, 75 a month.
Yeah, 100 a month.
Of at least 100 a month in restitution, towards the restitution. But give him 60 days upon his release.
Is he in on another charge?
No, he's in on this. There was a jail sentence before the probation. It's a followed-by case. Yeah.
Okay. Very good. Cool. And the defense is not in
No.
Okay. So we'll establish the minimum $100 a month payment, but it still needs to all be paid by the end of the probation, or you'll be potentially in violation.
Somebody else.
So the court will accept, based on the stipulation of both parties, restitution in the amount of $2,890.63, payable during the term of the probation, but $100 a month after 60 days minimum. So if you can get me an order, that'd be great. Okay, I think that's all, that's the last. Anything else, Mr. Berry? We got it all? Okay. Okay, so we'll reconvene at 1:30. At least we'll have an hour. Sorry, I couldn't give you a little more. We got a busy afternoon.
Victim is William Allen Fox.
Clerk, thank you.
Senior.